Hey everyone, thanks for tuning in. We're going to be starting in a little bit, 2 minutes after the hour, just to let some of our stragglers come in. So we'll start soon. Thanks for tuning in.
Hey everybody, welcome to the June 2nd webcast entitled Crime and Banishment. My name is Leo Rayner. I used to be a criminal defense lawyer.
Hey everybody, welcome to the June 2nd.
I heard myself. But I used to be a criminal defense lawyer for a couple of years. I summered with the Crown's office. Then I switched to immigration law, and I've been doing that for about 3 years now. My reason for talking to you today is just to chat about the interaction of criminality and immigration law. I will not be going very in depth into any particular topic. This will mostly be a primer on criminal inadmissibility, ways to overcome it, and ways to appeal it. This may serve as a good refresher for those members of the bar who are more experienced in this. It will be a great intro to those of you who are new. And I understand that some of our colleagues from the criminal bar may be joining us as well, and you may find this information quite useful. I know that probably about 60% of you here today are here simply because of the wonderful pun. Um, I'm sorry to say I don't really have any others in the presentation. And to the 40% of you who hate the pun, I am so very sorry. I'm going to go through the presentation, and if as you get your questions, please do type them in, and we will get to those at the end. I will not be taking questions in sections, but we will revisit the questions when we get to the end. So let me share the slides with you guys. Enbal, can they see the slides? Can you see it on your end?
I can see it on my end.
Excellent. Yeah. All right. So I will disappoint some of you first by saying that these slides are not going to be something that you'll be able to use as much of a referential tool in the future. It's mostly to help you follow along with my presentation. So before diving into details concerning criminal inadmissibility, it's important to understand the standard of proof of criminal inadmissibility. I apologize for that. The standard of proof can be found in Section 33 of the IRPA, Immigration Refugee Protection Act, and it reads as follows. You will see it on your screen. It states the facts that constitute admissibility under Section 34 to 37 include facts arising from omissions and, unless otherwise provided, include facts for which there are reasonable grounds to believe that they have occurred, are occurring, or may occur. Now, knowing what reasonable grounds to believe means is key to appreciating the often uphill battle that you will face when fighting to prove that a client is not inadmissible. So how is reasonable grounds to believe defined? It's been defined as something more than a mere suspicion, but less than the balance of probabilities, which is the usual civil standard. This was set out in the Supreme Court's decision in Mugusera in 2005 and continues to be the standard to this day. Now, that's a pretty broad range, as you can imagine, and it will cause you some frustration, I'm telling you right now. It may result in times when you feel that the case against your client is fairly weak, but at the same time, a board may find that it is strong enough to meet the standard nonetheless. When you combine this lowered standard of proof with the fact that the board is not bound by formal rules of evidence and is allowed to admit evidence that they find to be credible and trustworthy, sometimes even something like a Wikipedia article, be prepared to grind your teeth when dealing with this. You'll grind your teeth a lot. You may consider investing in a mouth guard to save on dental bills going forward. You will see some things that will make your skin crawl. Really, if you do much work in inadmissibility. Anyway, that little rant aside, let's get into actual criminal inadmissibility. I'm going to start with breaking down Section 36 of the IRPA. Section 36 contains an explanation of why both foreign nationals and permanent residents can be found inadmissible on grounds of either serious criminality or criminality. I will discuss these two separately. We're going to start with serious criminality. This is described in Section 36(1) of the IRPA. Both foreign nationals and permanent residents can be found inadmissible for serious criminality. Now, as you can see from the structure of the section, serious criminality can manifest in one of three ways. There can be a conviction inside Canada, there can be a conviction outside of Canada, and there can be the commission of an offense outside of Canada. I will discuss each of these three ways to be found inadmissible in turn, and once I break them down, it'll make the remainder of this discussion a bit easier on us. Let's start with convictions in Canada. That can be found in Section 36(1)(a) of the IRPA. As you will see, to be found inadmissible for serious criminality due to a conviction in Canada, you must be convicted in Canada of an offense under an act of parliament, punishable by a maximum term of imprisonment of at least 10 years, or of an offense under an act of parliament for which a term of imprisonment of more than 6 months has been imposed. The reason I have specific terms bolded in that slide is to discuss the definition of each, because even though just reading the section, it seems pretty self-explanatory, knowing the exact meaning of each of these terms is instrumental. We'll begin with a discussion of what the term convicted means. We need to realize that not every charge results in the conviction. For instance, some easy examples of that can be withdrawals, when someone is charged, but then that charge is later pulled by the Crown. Also, if you are acquitted after trial, that is also a non-conviction resolution. Another example would be a finding of not criminally responsible for a reason of mental disorder under Section 16 of the Criminal Code. Similarly, even if someone enters a peace bond and then their charge is withdrawn, this still does not count as a conviction, because entering into a peace bond is not an admission of guilt. Now, things get a little bit trickier when we take findings of guilt into account. Because while every conviction is a finding of guilt, not every finding of guilt is a conviction. Specifically, there are two particular resolutions that do not constitute convictions under Canadian law. Those are the absolute and the conditional discharge. These come after a finding of guilt, meaning the accused must either plead guilty or be found guilty. But if the sentence of an absolute or conditional discharge is imposed, it is not counted as a conviction, meaning receiving an absolute or conditional discharge for a criminal offense will not make you inadmissible to Canada for serious criminality. Everything else, however, any other finding of guilt is a conviction, and this is important to remember. For instance, imprisonment, well, clearly, anything resulting in imprisonment is a conviction. If you get a conditional sentence, meaning house arrest, that's a conviction. If you get a suspended sentence, meaning you don't spend a single day in jail, but you nonetheless get probation, that's a conviction. And perhaps one that catches people the most are fines. A fine is a conviction. So if someone is ordered to pay a fine, such as after a conviction for impaired driving, they are considered to have received a conviction for which they can be found inadmissible to Canada. Let's move to the next term, Act of Parliament. An Act of Parliament means federal legislation. Examples of federal legislation that constitutes Act of Parliament include, well, obviously the Criminal Code, the Controlled Drugs and Substances Act, and even the IRPA. Now, important to note that provincial and municipal legislations and acts do not count, meaning if you are convicted of speeding, if you get a parking violation, those are not grounds for being found inadmissible to Canada. At the same time, a similar event, but prosecuted differently, could result in an inadmissibility. For instance, if that speeding is instead charged as dangerous driving under the Criminal Code, inadmissibility may result. Now we move to punishable by a maximum term of at least 10 years. Before we get into this, we need to appreciate that there are two ways in which criminal offenses can be prosecuted in Canada. They can be prosecuted by indictment or by way of summary conviction. There are some offenses, very few, that are straight summary offenses, meaning they're the least serious of all offenses. In those, the Crown can only proceed summarily. There are also some straight indictable offenses that are the most serious of all offenses, where the Crown does not have a choice and it must pursue the most serious method of prosecution. But finally, the vast majority of offenses are something known as hybrid offenses in Canada, meaning the Crown has the opportunity to elect whether to proceed summarily or by indictment. What's important in the context of Section 36 inadmissibility is that that election doesn't mean anything. For the purpose of Section 36, every hybrid offense is deemed to be indictable. So even if you committed the smallest violation, if the section of the Criminal Code under which you are charged is a hybrid offense, you are presumed to have committed an indictable offense. So when looking at the maximum term of imprisonment, you must necessarily look at the indictment section of the offense. So if you're trying to find whether a client will be inadmissible due to a conviction and you flip open the Criminal Code and you find the punishment section of the offense, make sure you go down to the section that describes a punishment if prosecuted by indictment. Keep in mind too that the phrasing here of at least 10 years doesn't fully align with the phrasing in the Criminal Code. In the Criminal Code, maximum terms are expressed in terms of maximum, a maximum of 10 years. So for instance, any offense that in the criminal code has a sentence of a maximum of 10 years will constitute an offense punishable by a maximum term of at least 10 years. And you would be surprised just how many offenses like that there are. When you're looking, one important thing to keep in mind when looking at the maximum term of imprisonment is the timeline of when to calculate that term. For instance, if criminal law changes from the time of the commission of the offense to the time of the charge, or the time of the conviction, or the time of the inadmissibility finding, the legislation that you look at is the way that the law was at the time of the commission of the offense. For example, assume you have an individual who committed an impaired driving offense back in 2017. Back then, the maximum for impaireds was 5 years. However, on December 18, 2018, they bumped it up to 10 years. Assuming the justice system drags its feet and this gentleman is not prosecuted until 2020, when it comes time to figure out whether that person is inadmissible or not, we need to look back at the law at the time of the commission of the offense, meaning he would benefit from a sentencing regime where 5 years is the maximum. Finally, let's talk about term of imprisonment of more than 6 months. Oops. Even if this kind of catch-all term allows the government to find inadmissible people who may have committed objectively less serious offenses, but in a more serious manner. For instance, a simple assault has a maximum of 5 years, so an assault conviction would not trigger admissibility for serious criminality. However, if the sentence received is more than 6 months, the section would be triggered. Now, what constitutes imprisonment? Here, pardon me, imprisonment is exclusively a jail sentence. Periods of probation here are not considered periods of imprisonment. The time you spend having to pay your fine is not considered to be a term of imprisonment. And perhaps most importantly, conditional sentences, which is house arrest, are not considered to be a term of imprisonment, as per the Supreme Court's decision in Tran from back in 2017. So all of these pieces, convicted, act of parliament, maximum sentence, and terms of imprisonment, are important to be kept in mind because it's not always immediately obvious whether certain criminal conduct results in inadmissibility. For example, imagine you have a permanent resident who is sentenced to 5 separate assaults, who is convicted of 5 separate assaults and is sentenced to 5 consecutive, meaning back to back to back, sentences of 6 months each. This person would spend 2.5 years in jail, but they would nonetheless remain admissible to Canada. At the same time, if you have a person who commits impaired driving after December 18, 2018, and is sentenced to a fine and no jail time at all, that person will be found inadmissible under this section. So make sure to assess all of these elements. Now let's move on to talking about convictions outside of Canada and how these can make you inadmissible. As you can see from this section, the length of the sentence served is not taken into account. Instead, what will need to be considered is the equivalency of the foreign offense with the Canadian offense. I won't be going deep into equivalency. It's a pretty involved topic, so if this issue crosses your path, make sure you read up on the jurisprudence for assessing equivalency. But I will give you a brief rundown. So equivalency is more than just eyeballing offenses, saying, well, yeah, you know what, it kind of looks the same as this Canadian offense. No, an equivalency assessment involves things like comparing the wording of statutes, comparing the actus reus of offenses, meaning the actual act that led to the charge, comparing the mens rea for the offenses, which is comparing the mental element or intent that is necessary for convictions. Also important is the evidence that was adduced in the foreign court to secure a conviction, to see whether a conviction could be similarly secured in Canada, and even consideration of available defenses in each jurisdiction can be important to this assessment. Because unless the government can establish the equivalency between these offenses, there cannot be an inadmissibility finding. If you are going to be looking into this, I suggest starting with the Federal Court of Appeal decision in Hill, Hill. It's from 1987, but really you don't have to do that. If you look up equivalency in Can Lee, it'll take you 2 minutes to find a more modern decision that summarizes the jurisprudence since 1987. Now, if equivalency between offenses is found, then it's also important that there be equivalency between convictions. This harkens us back to our discussion on whether every finding of guilt is a conviction. Because there are circumstances where the foreign jurisdiction may have found guilt, but may have, in essence, sentenced this person to their version of an absolute or conditional discharge. If it can be established that this whole resolution would have been a non-conviction if pursued in Canada, then that's another way to succeed in combating this sort of inadmissibility. Now, finally, let's move on to the last part of section 36(1)(c. And here we're talking about commission of an offense outside of Canada. This one's pretty broad. It does not, what's important is it doesn't require a conviction. The board can rely on any credible information at their disposal to find this sort of inadmissibility. Example of when these can come up is if someone fled their country to come to Canada without facing their charge. So of course, there'd be no conviction. Or if they were charged in absentia after having already left their country. There can be many other variations where this section will come up, but that's kind of the cases that this section is aimed at. It gets, also it's important to remember that a foreign police force's decision or even prosecutorial decision not to proceed with a charge doesn't mean that the person cannot be found inadmissible under this section. Because even though there would not be a conviction, there may be evidence that an offense has been committed. Foreign acquittals get a little tricky. So though the IRPA explicitly forbids relying on convictions that ultimately turn to acquittals to find inadmissibility, there's not really clear guidance on whether people acquitted of foreign offenses can still be found inadmissible under this committed subsection, even without the conviction. So IRCC's old enforcement manual, ENF2, I believe, suggested that foreign acquittals were dispositive and that they should be respected, and that section 36(1)(c) inadmissibility should not be pursued. That manual is no longer active, and I was not able to find a present-day recreation of that principle. So don't really be surprised if even when acquittal comes up, an overeager IRCC or CBSA officer may still want to find inadmissibility under this section. However, that doesn't mean that acquittals are useless. If this comes up, you can still use the acquittal as evidence that an offense had not even been committed. This is especially useful if you have a foreign judge who comments on factual circumstances of the offense, or maybe even makes findings that certain things did not happen. So make sure to look at that. So this covers the basics of serious criminality. With these out of the way, we can move on to discuss regular criminality. That's section 36.2. I'm not going to spend long on this. Many of the basic concepts are the same. I'll just touch on the important bits, okay? To begin, you will notice that only foreign nationals can be found inadmissible for regular criminality. This does not apply to PRs. It takes a less serious offense to trigger this inadmissibility than for serious criminality. And that makes sense because Canada is a little harsher and shows less tolerance to those without permanent status because they have less of a tie to the country. While serious criminality requires either a fairly long sentence or an offense with 10 years or more maximum, any indictable offense whatsoever, so that includes every single hybrid offense, is enough to render a foreign national inadmissible for simple criminality. This means that convictions for offenses with lower max sentences, like simple assault or theft under, while they wouldn't really harm a permanent resident, they could still make a foreign national inadmissible. In addition, so really the only thing that wouldn't make a foreign national inadmissible would be a straight summary offense. So that is an offense that can be prosecuted only summarily. There are precious few of these offenses. Two examples are causing a disturbance in a public place is one, and fraudulently obtaining transportation is two, i.e. not paying for a cab. If a foreign national commits one of these offenses in one interaction, or even more than one of these offenses, but in a single incident, they will continue to be admissible. However, if they commit two summary offenses in two separate incidences, well, two or more, then they will face this inadmissibility. I'll paint you a all too vivid example. If a foreign national decides to hop into a cab naked, run out of that cab without paying, and then cause a disturbance, they would not be inadmissible for criminality if they are convicted on both counts of disturbing the peace and fraudulently obtaining transportation. However, if those same two offenses are split into two separate interactions, meaning the fraudulently obtained transportation happens on one day and the causing disturbance happens on another, and there is no way to say that they come out of the same occurrence, a finding of inadmissibility can result. The only real addition to simple criminality over serious criminality is that it also can result in a finding of inadmissibility on the basis of acts committed upon entering Canada. There, certain statutes are prescribed by regulation, and if these statutes are contravened on entering Canada, simple criminality can nonetheless be founded. These acts can be found in Section 19 of the ERPR, so of the regulations. But for anyone taking notes on this, they include the Criminal Code, Controlled Drugs and Substances Act, Firearm Act, Customs Act, the ERPA, and the Cannabis Act. So those are the prescribed acts. So that's the rundown on regular criminality. Now, one last thing I will mention before we depart from Section 36 is the impact of youth convictions on this type of inadmissibility. So inadmissibility for either regular or serious criminality cannot be based on either a finding of guilt under the old Young Offenders Act, it's no longer in force, or any offense for which the person receives a youth sentence under the Youth Criminal Justice Act. Be careful, however, since this only strictly applies to convictions in Canada. It does not say that youth offenses or offenses committed by youth while abroad would not result in inadmissibility. As strange as it may seem, both the Immigration Division and the Immigration Appeal Division in my research have consistently been finding that convictions obtained for or offenses committed as a youth while abroad can still lead to inadmissibility, because the exception granted by Section 36E is restricted specifically to Young Offenders Act and the Youth Criminal Justice Act, and does not explicitly allow for a search for comparable acts abroad. There's not that much jurisprudence on this, and I really do think that there is room for a federal court challenge on this, for this to be brought in judicial review. So if this comes up, I would say don't hesitate to argue that this is unreasonable, and you will see why a little later in the presentation. Next, let's talk about Section 37, organized criminality. This is the last section of inadmissibility I'll talk about before we move on to talking about ways to overcome inadmissibility or to challenge inadmissibility. So both subsections A and B of Section 37 deal with organized crime, whether it be domestic, foreign, or transnational in nature. While a pretty short section of the IRPA, Section 37 is one of those topics that you really can do a full hour presentation on. But I won't be doing that here. The key thing for you guys to remember as basics is that Section 37 does not require a conviction, and it also does not require a charge. It only requires that the permanent resident or foreign national be a member of a criminal organization or engage in an activity that forms part of that criminal organization's pattern of conduct. And remember, too, that these factual findings are all being made on the reasonable grounds to believe standard. This means that the minister does not really have very high bar to clear here. This can lead to some of those teeth-grindy Kafkaesque results that I mentioned before. For instance, I once saw a gentleman who bought $20 worth of meth from a gang-connected drug dealer, and that man was later found inadmissible under this very section because he was found to have engaged in an activity that is part of the gang's pattern of criminality. He himself was not affiliated with the gang, but given the breadth of this section and his unfortunate lack of representation, it led to this very strange result. Having mentioned reasonable grounds to believe, one thing I do want to mention before I move on is that under Section 36(1)(c), this is the one section where permanent residents actually benefit from a heightened standard of proof. Meaning, if the minister wishes to find a permanent resident, and only a permanent resident, inadmissible under this section for acts committed outside of Canada, they must do so on an elevated standard of balance of probabilities. Just wanted to make sure I mentioned that. Moving on to overcoming inadmissibility. So in this section, I will briefly chat about the 5 different recourse options that you have that you see up on the screen right now. They're not all applicable to all situations, but they are good to know. Let's start with pardons and record suspensions. So if a criminal offense is committed inside Canada and the person who committed the offense later obtains a record suspension, which for the last 10 years or so has been the name for a pardon here in Canada, this person is no longer inadmissible under Section 36. There's more to know about how to apply for pardons, but just as a general benchmark, know that if you are convicted summarily after 5 years, after the end of your sentence, you should be able to apply for your pardon, assuming that you haven't accumulated more offenses. And if you received a conviction for an indictable offense, then it would be a period of 10 years before you can apply for a record suspension. Now, pardons, and I will continue to call them pardons for the purpose of this discussion, just know that in Canada they're called record suspensions. Pardons do not affect Section 37 inadmissibility, because remember, for organized criminality, there is no need for a conviction, so a pardon really doesn't do much. Now, in terms of foreign pardons, these can be accepted, but only after an assessment of 3 distinct factors. These can be found in the 2001 Federal Court of Appeal decision in Saini, S-A-I-N-I. But the sorts of comparisons you're looking at are: 1, that the foreign legal system that provide the pardon as a whole must be similar to that of Canada. 2, the aim, content, and effect of the specific foreign law must be similar to Canadian law. And 3, there must be no valid reason not to recognize the effect of the foreign law. What this means is that while some foreign issued pardons may be accepted, others may not. If you have a criminal justice system abroad that, let's say, gives out a pardon after 1 or 2 years of a clean record, there's a really good chance that it will not be accepted as being analogous, because the systems are just too different. My advice on foreign pardons would be, if you're approached by a client who's received a foreign issued pardon or record suspension, if that client is not in a big rush to come to Canada, they can simply write to their visa office, their nearby visa office, for an opinion on whether this pardon will be recognized. Whether the response from the visa office is right or wrong, it will at least give your client an opportunity to know what the likely outcome of submitting their application is. And should the letter be in your favor, it can be submitted alongside with your application as being further proof that you should not be found inadmissible. Moving to rehabilitation. This option for overcoming inadmissibility is only available for out-of-Canada convictions and out-of-Canada criminal acts. It does not apply for in-Canada criminality. If an offense is committed in Canada, you need a record suspension. It's as simple as that. So rehabilitation only applies to Section 36 inadmissibility, so serious criminality and regular criminality. And just how offenses of varying severity can result in different types of inadmissibility, regular versus serious crim, the timing of when you can apply for rehabilitation also varies due to the seriousness of the offense. For a foreign national who is inadmissible due to having 2 or more straight summary offenses abroad, after 5 years from the time they finish serving their sentence, they are deemed to have been rehabilitated. They don't need to make an additional application, and they should be okay to apply for either temporary or permanent status in Canada. For an indictable offense that has a maximum of less than 10 years, once 5 years pass, the person has the opportunity to apply for rehabilitation. But if they wait an additional 5 years, so 10 years total, then they will be deemed rehabilitated without having to make any sort of application of their own volition. Finally, if someone is convicted of or had committed an indictable offense abroad, that would be equivalent to an indictable offense here in Canada with a maximum penalty of 10 years or more, they can apply for rehabilitation after 5 years, but they are never deemed rehabilitated. So this decision will remain discretionary in the hands of immigration authorities, no matter how long they wait. Now, let's say that there's no pardon and not enough time has passed for rehabilitation application. What are you left with? Well, you're left with the bottom 3 options on that list. You have the humanitarian compassion application, the application for ministerial relief, and the temporary residence permit. Humanitarian compassion applications, or H&Cs, are applications where you can argue that the humanitarian and compassion factors in your client's case are compelling enough to outweigh the seriousness of the inadmissibility. So this includes arguments about establishment in Canada, family ties, the hardship that the permanent resident would feel if they were deported to their country of nationality, what they would lose. And that is contrasted against the seriousness of the conviction. An H&C request is made pursuant to Section 25 of the IRPA, and it needs to be made in connection with a permanent residence application. Now, keep in mind that this section, Section 25, is not a catch-all for all inadmissibility. In fact, the more serious grounds of inadmissibility cannot be overcome with an H&C application. Specifically, inadmissibility from sections 34, 35, and 37. So security, crimes against humanity, and organized crime, you can't make an H&C application for that. So that means if you have someone who is found to inadmissible under Section 36 for, let's say, a drug offense, but there's an additional finding of inadmissibility of Section 37 as then being affiliated with a criminal organization, you will unfortunately not succeed in an H&C application. However, there are options for those who are found inadmissible under the more serious sections, such as 34, 35, and 37. They have recourse to Section 42.1 of the IRPA, or the Ministerial Relief Section. So this is an application directly to the minister, and it's a request for the minister to consider lifting, essentially, the inadmissibility. Unlike an H&C application where humanitarian and compassion factors are considered, and there's a consideration of how a reasonable member of Canadian society would view the situation, whether they would like to extend mercy or a helping hand, ministerial relief concerns itself more with the quote-unquote national interest. This includes considerations of the danger posed by the foreign national to Canada, either to Canadian citizens or to Canadian security interests as a whole. So you are more limited in the arguments you can make for a ministerial relief application than an H&C application. Sure, there are some intersections, and it doesn't hurt to throw in some H&C factors when making your ministerial relief application. It's just important to know that that will not be the focus of review. And finally, we get to the temporary resident permit, the TRP. So if an inadmissible person is looking for a temporary rather than a permanent entry to Canada, this is a good option for them. Think of this as a one-time waiver of inadmissibility for a single visit or for a single period of stay, after which the person is intending to return back to their country of nationality. Needless to say that it's not enough to want to come to Canada while being inadmissible to qualify for a TRP. Rather, the evaluating officer considers two factors. One, whether the need for the foreign national to enter Canada is compelling, and two, whether this compelling need outweighs the risks to Canadians and Canadian security caused by the foreign national's presence. Some examples of events where a TRP may be appropriate, but again, it's officer dependent, is attending a funeral, attending the birth of a child, if you can indicate that, if you can show that your inadmissibility does not stem from anything overly serious. Sometimes you can ask for a TRP for a longer stay, because a TRP is essentially a catch-all to get you more status when you otherwise may not be able, where you otherwise may be bound by the IRPA from getting it. Now, the last thing about the TRP is the TRP can be used against any sort of inadmissibility. So it's not limited to Section 36. Section 34, 35, and 37, the big boys, the serious ones, are not excluded. But do know that if you submit a TRP while you are admissible under those more serious sections. It will be scrutinized more thoroughly, and I believe it is immigration's policy to refer those files to more serious senior members of their team for review. So those are ways to overcome inadmissibility. But what if you don't want to overcome it? What if you want to challenge an inadmissibility finding? So a finding just came down, or you just had an admissibility hearing and it did not go your way. What are your options? I will discuss here. I will discuss judicial reviews, and in more detail, I will talk about the Immigration Appeal Division. If the applicant is a foreign national, then their recourse will always be to the federal court for judicial review. This also applies to PRs and protected persons who are not eligible for the IAD, but I will touch on that in a little bit about who's eligible and who's not. So a judicial review is limited to assessing the propriety of the admissibility decision. The court ordinarily looks at whether or not the board members or officers' decision was a reasonable one and makes a finding on this. If you are successful, the usual remedy you will receive is an order for reconsideration by a different decision maker. Now, the last point is that very rarely, and I do stress very, the court may substitute a substantive admissibility finding where really it is the only possible outcome. So let's say you had a board member who just misread the maximum penalty of an offense, and that is painfully clear that your client is not inadmissible. The court may substitute its own finding. Recently, in the Supreme Court's decision of Vavilov, the Supreme Court stated that the court should not be hesitant to do so. But again, this will be very rare, and you will likely not come across this. Now, some more interesting than judicial review is the Immigration Appeal Division appeal. This is not open to everyone. So here it's only open to permanent residents or protected persons in certain circumstances, which I will cover in a bit. But how does an appeal to the IAD differ from a judicial review? And why is it more advantageous? Because that is my position. First, unlike the federal court, the IAD is not bound by the record before the original decision maker. You're welcome to lead new evidence as you see fit before the IAD. It's not even limited by an evidence provision in the same way the RAD is, where it must be new evidence. I've never had issues leading new evidence of any sort I wanted in front of the IAD. Second, unlike the federal court, the IAD takes into account H&C factors and weighs them against the inadmissibility before deciding whether the removal order should stand. This is a big one because the court, it doesn't really matter if the court thinks that your case is compelling. If there are no errors in the immigration division's inadmissibility decision, there's nothing they can do for you. However, the IAD has the ability to actually assess the merits of your case and show you some leniency. And again, yes, whenever I say you, I clearly don't mean counsel, but the client. But it gives them the opportunity to assess H&C factors and show flexibility that is simply not available through judicial review. Now, the third difference that makes an IAD appeal more advantageous than judicial review, and the reason I put asterisks around it is because, in my humble opinion, this is the most important part, I would say even more important than the ability to lead H&C factors. It's the fact that IAD is not limited to either allowing the appeal outright or dismissing it. The IRPA gives the IAD a very valuable, for us as immigration counsel, middle ground, the ability to stay the removal order and impose conditions. This essentially gives the IAD the ability to institute a sort of immigration probation, if you will. That way, if they're faced with someone who does have a concerning criminal record on one hand, but on the other hand also has strong ties to Canada, support in the community, and other strong humanitarian factors, they're not torn between choosing between just letting them off the hook entirely or ripping them away from their families. And it's this middle ground that is so valuable about IED appeals, especially in cases where criminality is on the more serious side. So what do these stays look like? They are an imposition of conditions, usually for a number of years. I've seen them go up to 5. Your mileage may vary. And they include conditions like periodic check-ins with immigration officers, attending counseling, if any required by terms of a criminal probation, and always the term keep the peace and be of good behavior. If any of these terms are breached, then a new hearing would be convoked where the client would have an opportunity to argue why the stay should stay in effect and why their removal order should not be revived. They should have a really good explanation. The IAD does not look too kindly on breaches of these stays. However, if the breach is fairly minor in nature, you can encounter some flexibility. And keep the peace and be of good behavior condition is one you really got to keep an eye out on, and you really got to instruct your clients on, because this condition is not limited to criminal conduct. Technically getting a parking ticket and not paying it can constitute a breach of this condition. A speeding ticket can constitute a breach of this condition. Is it a major breach? No. Is it a breach that the IED may forgive? Yes. But if this was a close case from the beginning, you don't want to be adding these little things, and you don't want IED to have to reopen the matter. When stays are issued, there's also usually periodic check-in periods with the IED, maybe once a year, once every 2 years, they'll set down another hearing just for a check-in. Sometimes stays can be terminated early, and if the permanent resident or protected person adheres to all of the conditions of the stay, far more often than not, I would say almost always, the removal order will be set aside and they'll be allowed to go on their way. One thing to remember is that there is one way to irrevocably ruin a stay, and that is to be convicted of an offense, of another offense that would make the person inadmissible under section 36(1), so serious criminality. At that point, there's not going to be a hearing, because by operation of the law, that stay will be terminated. Now, as I mentioned, not every PR and protected person who is found inadmissible for serious criminality, specifically, because that's what we're talking about, will get an access to the IAD. Here are 3 things that you should remember. First, only persons admissible for convictions inside Canada can appeal to the IAD. Those people who got their convictions outside or are inadmissible due to commission of an offense, their recourse, should they wish to appeal, would be to the federal court for judicial review. Second, as I mentioned, actually I have not, but second, persons who are inadmissible for organized criminality, section 37, also cannot appeal to the IAD. If we're talking in the criminal context, it's limited to section 36. Finally, if the offense underlying the inadmissibility was punished by a term of imprisonment of 6 months or more, there can be no right to appeal to the IAD. In practical terms, this means that knowing how to properly calculate your client's sentence is imperative, because even a single day of difference from 6 months to 6 months less a day would make the difference between having access to a very robust method of appeal through the IAD or being limited to a far more limited method, such as the judicial review. So when doing these calculations, here are some things to keep in mind. Number one, do not, under any circumstances, rely on CBSA or IRCC documents in calculating the sentence. Several times I have seen them misstate offenses, misstate sections, misstate the sentence, calculate it wrong, make a mistake over whether a sentence is consecutive or concurrent. And I'll tell you one thing, those mistakes that they make, they will not be in favor of your client. So make sure that you are quite critical of the documents you receive from CBSA and IRCC, specifically their reports where they summarize the convictions and the sentences. Instead of relying on those, you gotta get your hands on the criminal court documents. Here I'm talking about the warrant of committal, the copy of the information or the indictment. Those are the charging documents that will, after the matter is concluded, list the sentence. And perhaps most helpful of all, or at least most clear of all, not always helpful, would be the reasons from the judge. You can, with the help of the criminal lawyer, this is something that you can often be able to obtain, and nothing sets out the breakdown of a sentence better than the judge's own oral reasons. I've had cases where even the warrant of committal was unclear. The notations were not clear. There was an entry, for instance, that said -6 months. And there was a big disagreement between me and the minister of whether that dash constituted a hyphen or a minus sign to suggest that it's supposed to be less than 6 months. Luckily, I was able to get my hands on the judge's reasons, on the transcript of that, where the judge very clearly stated that to maintain the IAD right of appeal, it was sentencing the client to less than 6 months. So get your hands on that. Third, when calculating sentence, remember that what you are calculating was the sentence imposed and not the time actually spent in custody. For instance, if you have someone who doesn't make bail, they sit in custody for a year awaiting their trial. Ultimately, they get found guilty for a minor offense, and for it, they get sentenced to 1 week. And they detract that 1 week from their pretrial custody. This person, despite spending more than a year in custody, would nonetheless stay eligible for an IAD appeal. However, let's contrast this with someone who spends 5 months in pretrial custody, enters a guilty plea to a more serious offense. The judge sentences this person to 7 months imprisonment, but because of enhanced credit for their pretrial custody, they are at a time served position, meaning they are immediately released from custody. Here, you're going to have a person who spent less than 6 physical months in custody, but who would not be eligible to apply to the IAD. So make sure you're looking at the right numbers. And finally, remember that what is assessed is the punishment for each individual offense rather than the global sentence. This means that you can have global sentences that exceed 6 months, would nonetheless maintain their ability to apply for the IAD appeal. An example of that would be someone charged with 3 counts, the total sentence for which will be a year, because the judge finds that the seriousness of the offenses should result in the 1-year punishment. But if that person is sentenced to 4 months for each of those counts individually to be served consecutively, meaning 1 after the other retain their right to appeal to the IAD. So this ends my summary of ways to combat admissibility. We're entering the home stretch here, guys, so just stay with me. The final topic I want to cover before we dive into Q&A would be strategizing with criminal counsel. And if my criminal colleagues are still here, this could be important for you as well. So it's not uncommon for criminal lawyers to reach out to us to discuss impacts of certain convictions or sentences on their client's immigration status. This is understandable, seeing that in the recent years there have been several high-level appellate decisions, like Wong 2018 from the Supreme Court, for example, stressing the importance of criminal defendants and their counsel knowing the possible immigration consequences of entering guilty pleas or of particular sentences. While criminal lawyers may be calling you with a very specific question, I urge you to make use of these phone calls as a strategizing opportunity. This can both help the criminal lawyer and you if you end up with the immigration file down the road. Put in other words, don't just confirm for the criminal lawyer that the client would or would not be inadmissible following conviction, but instead see if you can advise them at ways to either make admissibility easier to appeal by maintaining access to the IAD, for instance, or how admissibility concerns can be avoided altogether. Here, I'll give you two possible examples. So if you get a call from a criminal lawyer to see if a conviction for impaired driving will result in inadmissibility for a foreign national. The simple answer, of course, is yes. You can just tell them yes, hang up the phone, because the impaired driving has a mandatory minimum sentence, so a discharge is not even an option, and that's a hybrid offense. However, rather than just saying yes, you can also suggest to that criminal lawyer that she negotiate with the Crown to see if they would be willing to amend the charge to something like dangerous driving. The beauty of dangerous driving is there is no minimum sentence for dangerous driving. If this amendment is made, see if the Crown is willing to let the foreign national do a whole bunch of upfront work, volunteering, make charitable donations, and see if the Crown will be willing to put forward a joint position on an absolute or conditional discharge. If successful, and if that penalty results, you've gone from a situation where inadmissibility was all but a guarantee to a situation where there is no inadmissibility at all. Or consider this example. A criminal lawyer calls you to ask about a client's upcoming plea. The client is a permanent resident and will be pleading to 4 counts of fraud over $5,000. Jail time here is a guarantee, and given the amounts of the frauds, the appropriate sentence is somewhere in the realm of 2 years. It will make the client inadmissible. Just like with the previous example, if you were just to provide the information asked for, the answer is simple. The answer is yes. Fraud over is a straight indictable offense. There's not even an opportunity for summary prosecution. It has a maximum of 14 years. So regardless of the sentence, the client will be inadmissible. However, again, rather than saying yes, explain to the criminal lawyer the importance of the IAD appeal right and how what steps can be taken to make sure that the client stays eligible. Because if a client just takes a global sentence of 2 years, a concurrent sentence on all counts, meaning it would be 2 years per count, but to be served at the same time, they won't get access to the IAD. Suggest that the lawyer advocate for 4 separate 6 month less a day, meaning 1 day less than 6 months, sentences that run back to back or consecutively, instead of a single 2-year concurrent sentence where all the sentences run at the same time. given that there's been quite a lot of appellate guidance and comment on the importance of recognizing immigration consequences, encourage the criminal lawyer to explicitly refer to the judge, because criminal judges are quite receptive to this. And as I mentioned in one of my previous examples, they sometimes even explicitly put it on the record that their intention is to allow this person to maintain their IAD appeal rights and that they are sentencing them accordingly. In summation, these calls with our criminal law colleagues are very valuable opportunities to preempt problems. So make the most of them. So this ends the primer on criminal inadmissibility. As I mentioned at the outset, even though I've given you a lot of information today, I know there's a lot more depth to all of this. There are also some other interactions between criminality and immigration law that I didn't have a chance to touch on, but you should make sure you look into if they come up. I'll just list them off so they're fresh in your mind in case these issues come up. For instance, criminal inadmissibility also interacts with the refugee protection process, and certain criminality can make applicants ineligible for refugee protection, which is pretty important to know. This criminal inadmissibility can also limit the scope of a pre-removal risk assessment application, where if a person serves a long enough time, they will be limited at what grounds of protection they can argue in their PRA. Then there's also the matter of danger opinions, or how protected persons can still be removed from Canada, even if their criminal record gets bad enough, and how these danger opinions are considered and adjudicated. Then there is the fertile area of immigration detention and ways in which immigration detention interacts with criminal detention, and which takes primacy, and how can release from one affect the other. All of these things are important interactions for you to look into. So to say in other words, criminality has the potential to have an impact on a very wide range of immigration applications and circumstances. So whenever criminality is present, be sure to consider its impact very carefully. And that's it for me. I will happily take your questions for those of you who may still be there listening to me ramble.
Thank you so much, Leo. That was a lot of information. I think I'm going to have to rewatch this again afterwards because I was getting a lot and I was like, wait, what was that? So I'll be watching the replay. We had a lot of questions for you in the comments.
Oh boy.
We'll give a shout out to Justin Toe for answering some of them on your behalf. Thank you. Much, Justin. And I think we'll maybe try to do some of the quick ones first and not get people out of here too late after 2. This was sort of already answered, I think, but does time in custody count towards the 6 months, and is there case law on it?
So time in custody can count towards the 6 months if the judge explicitly takes that time into account of fulfilling the sentence. Well, what's important here, and what you will see on these documents, the warrant of committal, the information, the indictment, it will have 2 different entries. It will say the actual sentence, and it will also say how much time spent in custody and what sort of enhanced credit was provided for that pretrial custody.
And then I think this was also already answered. If someone was sentenced to back-to-back sentences that are individually less than 6 months, cumulatively more than 6 months, is that admissible or inadmissible?
Assuming they are otherwise admissible, yes. That is admissible, and that's really the main tactic that we can advise criminal lawyers of, is advocating for these consecutive sentences. This will come very counterintuitive to a criminal lawyer, because the default sentencing regime in Canada is to provide concurrent sentences, but in immigration related instances, consecutive sentences are king. really.
That's very interesting. How would 36(3)(e) apply to a youth who received an adult sentence?
If you receive an adult sentence, then it doesn't apply. Then you would still be inadmissible. It explicitly refers to sentencing under the YCJA, because the YCJA it doesn't have offenses. I'll put it that way. The offense you'd be charged with as a youth will still be under the criminal code. The YCJA just provides the procedures to be taken when prosecuting that offense. If they bump you up and you get an adult sentence, you're admissible. You're treated as an adult in the eyes of immigration authorities.
And how does cash bail affect the status of an immigrant?
I guess being out on cash bail. If we're talking about someone who is on cash bail in Canada or on any sort of bail, that will not impact their status, because for a Canadian offense to impact status, there has to be a conviction. So if someone's just either in pretrial custody or released from pretrial custody awaiting trial, no inadmissibility proceedings will be commenced. However, should they be convicted, that's when the minister will start getting involved.
And I think this was already answered, but if you want to talk about how TRAN impacts in general, how if the maximum penalty has decreased from the time of the offense, from the time of the offense to the time of sentencing, do you still use the maximum time for the offense? And I think that's something that TRAN sort of addressed, but maybe you can speak on that.
I don't want to. When I was re-reviewing TRAN for the purpose of this preparation, it's not an issue I looked into deeply. I don't want to mislead anyone. All I can say is what I've said in the presentation. If there's been a change in the sentence to the detriment of the applicant, the sentencing regime at the time of the commission would apply. I am not in a position right now to comment on whether, if things have improved, whether you get the benefit of the new provision. Sorry, guys, didn't come prepared for that one.
Then we have, is it a good practice to get a legal opinion from a criminal lawyer for 36(1)(b) related allegations?
Yes, I would say so, because they would have a better understanding of their country's criminal law and the requirements of each section. Keep in mind, when requesting such an opinion, I would provide the criminal lawyer with a template, or at least with a list of factors that they need to make sure to mention. If you just ask for an opinion, you may very well receive a single-page document that says, I looked at the Canadian offense, I looked at our offense, they're equivalent. This will be of very little probative value. Instead, write to the lawyer, get them to comment on the things I mentioned and the things that come up in the case law, such as similarity in statute, mens rea elements, actus reus elements, evidence tendered at trial, and available defenses. The beauty is, if you are a sleuth and really research-minded, you can put together a pretty damn good opinion of this yourself. But of course, it is nice if you can get the criminal lawyer from that country to confirm your assessment.
Okay, this one I'm not sure I understand, but hopefully you will. Does a foreign conviction that is equivalent to a conditional discharge prohibit CBSA from proceeding on a commission of offense grounds for the same act? The example given was some people get equivalent of a conditional discharge for passport misuse, and then CBSA treats it as a commission as most serious passport fraud.
Mm-hmm. This is what I personally very much don't like about Section 36(1)(c) or any of these committed sections is that with the removal of the old enforcement manuals, there is no longer much consistency to how CBSA or immigration officers approach this sort of equivalency. To stop talking around the question, my position is you can absolutely find an officer that will find an admissibility under section 36(1)(c), even if you can demonstrate that this person received a discharge, an equivalent of a discharge under section 36(1)(b). I really wish there was stronger wording from the minister prohibiting this kind of double-dipping conduct, but to my knowledge right now, there isn't, and there's not much consistency.
And there's been a few questions about 1.5 times served, and I think I can distill it to, like, is time served treated differently if it's, for instance, treated as 1-to-1 in criminal proceedings versus if it's treated 1 to 1.5? How does that affect the immigration and admissibility side?
Sure. First, my reference to 1.5, if I have criminal colleagues out there, yes, I know it's outdated. It's not, that used to be the standard. I think now it's 1.25. They dropped the enhanced credit. But ultimately, what it comes down to is what sentence, the sentence that is looked at is the sentence that the judge thought the convicted person deserved prior to the application of any enhanced credit. So if a judge finds that an appropriate sentence is 6 months or 6 months plus 1 day, but the person only served 5.5 months and the judge chooses to give them enhanced credit, that's inconsequential to the assessment. It's the sentence that was imposed. As you will see from the wording of the section, what it concerns itself with is the sentence imposed, not the sentence served or the administration of that sentence.
And what is the standard of proof for demonstrating that organized crime activity occurred under Section 37?
Oh, it is a reasonable grounds to believe. It's all, as Section 33 applies to the whole swath of sections that it mentions, meaning the standard is unfortunately very, very low. You will often see it proven, this connection or activity, on paper by a very short letter from a police officer saying, I reviewed all of the evidence and therefore I find there's a connection with the criminal organization. That's what you will likely see at the detention review stage. And immigration division members often take that to be gospel. And even after that, standard of proof is real low.
And I have here a clarification question. So time spent on restricted bail is not considered, but conditional sentences are considered custodial sentences for the purpose of calculating the length of the sentence. Correct?
They are not. They are not.
They're not.
So conditional sentences are not considered to be sentences, terms of imprisonment. I'll put it that way. And the Supreme Court's rationale on that was that it would result in a perverse result where someone may receive a 5-month custodial sentence and be admissible, or at the very least have access to the IAD, while someone else who committed a less serious offense and thus be eligible for a conditional sentence may receive a year of house arrest, but then be inadmissible or lose their ability to apply to the IAD. To avoid this kind of perverse result, it is taken to be that conditional sentences are not considered to be terms of imprisonment for the purpose of looking at Section 36(1)(a) and of looking at your IAD eligibility.
Okay, I think I'm going to wrap things up there. I may have missed some questions in the comments. I really apologize. Leo, would you be okay if people email you?
Sure.
if I miss their question.
Yeah, guys. If there are any questions, email me. If I made a horrible mistake and you want to let me know just how wrong I am, also don't hesitate to email me. We're all in this together, and we all want to do a good job for our clients. So just email me at Leo, that's Leo, at legallycanadian.com.
Perfect. So let's wrap this up. We've already gone a little bit over time. I just want to mention we had some technical difficulties at the beginning, so I didn't get to say this. We're thinking right now about the criminalization of Black, Indigenous, and otherwise racialized communities in Canada. We've made a post in our Facebook group to discuss this and how this affects our bar. So I suggest you look at it and engage in our discussion. The next webinar has not been set yet, so keep an eye on your emails, and we hope to see you here again soon.